Back on MorningLine, thanks for joining us. Our guest with us this morning, a professor from Vanderbilt, James Blumstein. We're talking about the Supreme Court decisions. As I suspect, we're focusing a bit, and there's a couple things more I want to talk to you about with regard to the same-sex marriage ruling. And if you want to sound off, give us a call, 737-7587. Let's go next to Greg. Greg, good morning.
Hey, good morning, guys.
Hey, Greg.
These kind of things irritate me. First to answer, I got a couple of things to say, but to answer your first question about churches, if they have to perform these weddings, no, they don't. It's just the same thing as Roe versus Wade. They couldn't force hospitals to perform abortions, just like they can't force churches to perform these weddings. So if these guys want to try to get this wedding and call it a wedding, they can go to their little make-believe churches and get their little stuff all officialized as if they're really a legitimate marriage, which is never going to happen.
Well, you don't always have to get married at a church under any circumstance. You can just go to the clerk's office.
Right, and I think
I hear you.
I think the caller is right that a church cannot be forced to perform a wedding against its religious precept. The question becomes whether, if they refuse to do that, if they act in what would be considered a discriminatory manner by the advocates, whether they can keep their tax-exempt status. That's the question.
Greg, what was your other comment?
So in other words, what he's just saying now is that the government's going to threaten churches that if you don't marry these sick people, then they're going to try to go after you monetarily.
Well, we don't know what will happen.
That's the next question.
That's what he's insinuating with that comment.
Yeah,
churches better do it, otherwise they might come after you monetarily. But the other comment I'd like to make is just that isn't it always strange how we've got 81% of Tennesseans in this country, in the state, plus 28 other states that are all opposed to this. And then the Supreme Court tries to overrule us. No, they have no right to overrule the citizens of Tennessee, and the citizens of Tennessee need to stand up for that. But how come we always come up with these 5-4 decisions? It's always close. I think it's so... the Supreme Court is not a legitimate organization anymore. They're judges that have been all paid for, and they end up with these decisions that always side with the government. And they always come across as if it's close. And it's just a coincidence that the Friday before all these gays have this big gay march is when they come up with their announcement. They couldn't come up with it 2 or 3 weeks ago. So you got this big photo op and this big sales thing going. And this is all we're doing now is all talk radio, the Valentines and the Journos and Bristol and all those guys. They're all selling this to the public now. And just like your show, for example, you don't have anybody that's in opposition to this. It's just open line last night. There was 3 people that was all in favor of this, and now you've got him here, and he's in favor of it, and you're in favor of it too, Nick, because it's your job. But
well, no, hang on. We're not here we don't have people here taking either side on this issue. I certainly have an opinion on what I think, and you can probably figure that out, but that's not material here. As far as the professor here, he's right down the middle. I mean, he's telling us what he's observed. But I disagree with him on a lot of points there, including the fact that the Supreme Court's no longer relevant.
Well,
he's just wrong.
He has some good points, I think, about the court splitting 5-4. It has split 5-4.
Not all the decisions are 5-4.
Not all, but many are, and they have historically been by 5-4. And that's what the dissenters were saying, is that this was a political choice, not a constitutional choice. I think the Chief Justice ended his opinion by, in a very poignant manner. He said, if you're among the many Americans who favor expanding same-sex marriage, by all means celebrate today's decisions, but do not celebrate the Constitution. It had nothing to do with it. I respectfully dissent. So, I mean, that's pretty strong language, and I think that there's a very good and honest debate about whether this issue, as the caller was suggesting, should be a decision made by individuals, or whether the court should constitutionalize this set of preferences. And where there's stronger textual support, it's easier for the court to do that.
Is there any precedent where the court has done this before? Is there not this type of decision that maybe, of course?
There are some areas, for example, in abortion was an example where the court set the tone by initially labeling the right of a woman to choose whether to terminate a pregnancy was fundamental in Roe v. Wade. That was 1973.
What about civil rights decisions?
Civil rights, but those are more firmly rooted because the Equal Protection Clause has roots in equal treatment for blacks and whites, has a racial component.
Okay.
This is a more untethered, shall we say, judgment with its constitutional roots not as firmly planted, let's just put it that way, as in the race cases. Next time, as I said, next term, we're going to see if the notion of race neutrality prevails in college admissions, or whether universities can preference minorities in admissions, and if so, under what circumstances and through what criteria. That issue was decided also in 2003 in the Michigan case, and it was decided in the Texas case 2 years ago. The Court of Appeals took the case up and seemed to disregard what the Supreme Court said, and so the court's going to get another bite at the apple to decide whether the lower court really adhered to its decision or disregarded that decision.
Let's go back to some more phone calls. Let's go to Taylor. Taylor, good morning.
Good morning, Nick.
Hi,
and
Taylor.
Good morning to the professor.
Good morning to you.
I found this whole situation with the gay marriage very, very interesting, and I oppose it, but that's beside the point. There's no surprise that Kennedy wrote the majority opinion, because he's the same justice that wrote the opinion in the 2003 Texas sodomy case that the professor spoke of earlier. And as to the next challenges, the ACLU yesterday let it be known that they no longer support the freedom of religion statutes or protections that the religious community has in this country, and so they will be going after the churches and so forth that refuse to grant these marriages. As the previous caller said or mentioned, out of the 36 states that had already had gay marriage going into Friday's opinion, only 3 states had voted that as a statewide voter referendum. The rest had all either been done by the legislature, and that was only a few, but most of those, some 25 of them, had been decided by court opinions that legalized gay marriage. So my point is, I think Roe versus Wade has never been accepted by a large number of people and institutions, and this one is going to be contested and fought for even more vigorously than Roe versus Wade. One good opinion out of the Supreme Court was yesterday. They announced the EPA will have to consider costs when they're proposing rules for industry or whatever. Thus far, cost was not a factor that they took into consideration. So that's my point, and have a good day, and thanks for the show.
Thank you, Taylor.
Let me say about going forward. I'm not familiar with what the ACLU's position is. I'm going to, after this program is over, I'm going to go find out what their statement was. I think that the victors in this case, and it's clear that the advocates for same-sex marriage, from their perspective, may want a big victory. But in victory should come magnanimity, and that is to respect people who disagree. The court, the majority, Justice Kennedy, went out of his way to change the rhetoric that had been in some of the earlier cases. In the earlier cases, he'd said there's no reason to oppose same-sex relationships except animus or hostility. The word animus or hostility did not really appear, although some would argue it was implicit, but that was taken out of the opinion. And Justice Kennedy went out of his way to say that people who can be sincere and have very strongly held beliefs that are contrary to the Supreme Court's position here, and he thought that was important that folks be encouraged to continue to debate these issues, even though a cynic would say, but debate them would have no effect on it. But people can protest, just the way in the abortion area. Abortion is legal, but the number of abortions has gone down. People have made some inroads by talking about the issue and persuading, and so I think that opportunity for persuasion is still there. But if the advocates push for the loss of tax-exempt status, say for the Catholic Church or for other religious organizations who would find performing these marriages to be a violation of their faith tradition, that would be both legally and strategically a huge mistake. It would galvanize opposition to this in a way that would cause problems for the advocates. I think that it's imprudent, and I think that when one wins a big victory like this, there are other issues that the gay community has not yet succeeded in. For example, gays can now be married, but in states that don't have protection laws, they can be fired. Nobody must hire somebody based upon their sexual orientation. The Equal Employment Opportunity Commission is attempting to change that by regulation, but it's far from clear that they have the authority to do that. They were claiming it's sex discrimination. That's a contested question. But if in fact the goal is to have a more inclusive society, part of that includes tolerance and respect. And gays have been the subject of intolerance and disrespect, and part of that is very heartfelt and sincere religious belief. You don't do turnaround. At this point, I think it's a fair question whether employers, large employers particularly, shouldn't have to respect the workplace and have sexual orientation as a non-factor in the discussion about who's going to be employed or fired. But that will require some political muscle, shall we say. And I think that if the gay community turns out to be spiteful and hateful, it's going to be difficult to make those future advances. So I think some restraint and some mutual respect and some magnanimity is called for, especially not calling into question the sincerity of religious belief of organized religion such as the Catholic Church.
I see your point. Listen, on that we have to take a break. Philip, Tony, Butch, and others will get to your calls when we come back right after this. Stay with us. All right.